Hello, my name is Craig Altman, and I'm the founder and president of Tradition Software and Tradition Lien Service. We are headquartered about 30 miles west of Chicago. We are a national company that's been in business since 2005, and we help companies across the U.S. navigate construction lien law. And today we're going to be talking about Missouri's construction lien law. Okay. So Missouri is a state that means a lot to me. As you can see from my sweatshirt here, I've got a St. Louis University sweatshirt on. My daughter just recently graduated with an accelerated Bachelor's of Science degree in nursing from St. Louis University. I have run in the St. Louis Arch National Park, and I have camped and backpacked at Samuel Baker State Park downstate. It's a beautiful state, and construction lien law there is not too difficult, with one exception, which I'll go into shortly. But before I do that, I have to give you the standard legal disclaimer, and that is Tradition Software, Tradition Lien Service, and myself make no warrant, express or implied, for the use of this video, our websites, our software, pre-lien to lien, or the documents prepared by Tradition Lien Service. In no event shall Tradition Software, Tradition Lien Service, or myself be liable to anyone for any problem, claim, or loss arising out of the use of our videos, websites, software, or document preparation services. Tradition Software, Tradition Lien Service, and myself are not engaged in practicing law in the state of Missouri, nor does Tradition Software, Tradition Lien Service, or myself provide legal advice in the state of Missouri. Okay, so let's talk about construction lien law here, and I am going to share my screen. As always, with both Tradition Software and TraditionLien.com, lienservice.com, excuse me, we have a drop-down menu right off the homepage of both websites that talks about construction lien law alphabetically. So I'm going to bring up Missouri here for both Tradition Software, and also I'm going to bring up Missouri here as it relates to Tradition Lien Service. Now, Missouri is a state initially that does not require a first notice for your subcontractors out there, okay? But through pre-lien to lien in Tradition Software, which is leased from Tradition Software, and from Tradition Lien Service, if we were to prepare documents for you, we strongly recommend that kind of a generic preliminary notice that we've prepared go out to remind people on either private commercial projects or existing residential or new residential projects that your company, whether you're supplying equipment, labor, materials, or services, and you might even be a general contractor on the project, that you have future lien rights. And good companies across the US send this notice out almost religiously or as part of their standard credit policies. And they send them out not only in the 15 or so states that absolutely require it when you're a subcontractor or supplier, but they even send it out in states that don't require it. And Missouri is a state that doesn't require it, but we strongly suggest, without it being legal advice, that you do send it out. Now, for general contractors in Missouri, a general contractor must provide to the owner a notice to owner. And it must be given at contract time, right at the beginning of the project. So that is something that as a general contractor, you do need to be aware of as it relates to Missouri lien law. Okay. Now, all that being said, what makes Missouri unique as a state is that they not only require a warning notice to go out, and there's only a handful of states across the country that require warning notices. Residential projects in Nevada, residential projects in Illinois, Kentucky and Tennessee both require a warning notice. Oklahoma requires a warning notice. And Missouri requires a warning notice called a notice of intent to file a mechanics lien. And this is for subcontractors, but it's strongly suggested too, if you're a general contractor, you do this, but is absolutely by law required for general contractors. And this particular notice, what makes this notice unique is that it must be done 10 days prior to recording a mechanics lien, okay? And not only does this notice, and here's an example of the notice here that you would send out, not only does it need to go out prior to recording a lien, but it also must be served by a process server. And it must be served by a process server to the owner of the project. And also, if you're the subcontractor, it must be process served on the general contractor on the project. And ultimately, if you got to go to court in a fight over the recording of a construction lien in Missouri, you're going to need to provide an affidavit of service that I'm showing here as it relates to somebody like Aristocrat Process Servers, which is a process serving company that works across the state. We've used them in multiple cities in the state of Missouri. You're going to need to provide evidence that actually the warning notice was delivered by the process server. Now, sometimes the process server can't deliver that for whatever reason. The person's locked their doors or this or that. And that's not the end of the world. That ultimately can come up in court, and I can't advise you as to how that might go. But you do need to pay a process server, and it's generally around $60 or so for a process server to do that job, okay? Now, that being said, in Missouri, after the notice of intent to file a mechanics lien statement goes out, you do have a little bit more of a generous deadline to record a construction lien in Missouri. Most of your states, and I'm going to guess at about 40 states or so across the US, have a 90-day deadline, which is pretty easy to remember if you're a national company. But Missouri gives you up to 6 months after the last day of providing equipment, labor, materials, or services for a project. Though that time frame is shortened to 60 days for subcontractors providing rental equipment for a project, okay? Now, again, through pre-lien to lien, our software solution, you can prepare a mechanics lien statement and do it yourself and record it in the county where the project is located. It's not the easiest thing to do, though. So Tradition Lien Service can do it for you for $170. And that most of the counties in the state of Missouri, that's going to include e-recording, okay? And then after the lien is recorded, you have up to 6 months on commercial projects, existing residential projects, and new residential projects in the state of Missouri to have an attorney commence a lien foreclosure action, okay? And again, you know, you might get paid about 25 to 33% of the time initially when a lien is recorded against the property. And of course, that lien should be sent by certified mail to the property owner on the project at the very minimum. But a lien foreclosure then must be done as soon as 6 months after the lien is recorded in order to totally sure you're going to be paid. And that's where you're going to contact a licensed attorney in the state of Missouri. Okay. So we would love to work with you here at Tradition Software and Tradition Lien Service. We are located in suburban Chicago in Warrenville, Illinois. We are open from 8 a.m. to 5 p.m. Monday through Friday. And you can reach us at our 800 number. And our 800 number is always 800-886-8770. And if we aren't able to answer the phone, and more often than not, you're going to speak with me, just leave a brief message, and I do promise we'll get back with you shortly. Okay? Have a good day, and we look forward to talking to you soon. Take care. Bye.